Hi everyone, and welcome back to our fourth mini review session on vices of consent. So Article 1948 provides that consent may be vitiated by error, fraud, or duress. We begin with error. Per Article 1949, error vitiates consent only when it concerns a cause without which the obligation would not have been incurred, and that cause was known or should have been known to the other party. There are three main ways in which we can analyze error and three main ways in which error may occur, and these include error of law, error of fact, and error of person. So we begin with error of fact. An error of fact is an error as to the existence of a fact or in the assessment of a situation, which error amounts to a vice and as such is a ground for action in court or a ground for liability. An error of fact may occur in nature or kind, meaning that it's an error as to the nature or the kind of the contract that the parties wish to enter into. An example of this would be a contract in which one party thinks they're entering into a contract of loan and the other party thinks that they're entering into a contract of deposit. An error of fact as to object refers to an error as to the identity of the thing which is the principal object of the contract. So there's a material factual mistake in what the actual object of the contract is. For example, if the buyer of a car believes that he's buying a BMW and the seller believes that he's selling a Honda Civic, there's an obvious error as to the object of that contract. An error bearing on substantial quality of the feature or the thing is evaluated on an objective and subjective standard. So an objective standard is more likely to lead to nullity. And when we're talking about the substantial quality of the thing, the objective standard is evaluating it as a reasonable person would. Whether a reasonable person would be displeased with the quality of the object they receive. So for example, if a buyer orders a necklace and he intended to buy a necklace that was made of gold, and instead he receives a necklace that is made of silver, I think this would be objectively an error as to substantial quality, and I think that objectively anyone would be displeased with that kind of error as to quality. In terms of a subjective substantial quality or error as to substantial quality, this is subjective to the person who is contesting the quality of the object. A subjective substantial quality error is less likely to result in a nullity, but it's still possible if the other party knew or should have known of the importance of the quality. So if a buyer orders on eBay a 2012 television and they get the 2012 television but thought it was a 2013 television, I think a reasonable person would say, well, is there really that big of a difference? But it comes down to how important the year of that television was and whether or not the seller on eBay knew how important the year of the television was. An error of fact in terms of cause is an error bearing on the reason why a party obligated himself in the first place. In order for this kind of error to lead to a nullity, the cause must be communicated to the other party, or circumstances must indicate that the other party knew or should have known of the cause of the contract. So for example, if you go to a thrift store that's specializing in selling watches and on the counter there's a watch and you think it belonged to RBG, and you tell the salesman at the thrift store you're so amazed that this is RBG's watch and that the very reason you're buying this is because it belonged to her, and the cause for entering the contract is known by the seller. So you buy the clock and later find out it belonged to Scalia, not RBG, and the clerk at the thrift store knew this. This is an error as to the cause of the contract, and this will vitiate consent. An error of law can occur in a couple of ways. So it can occur in a misunderstanding of the law, which occurs when one party knows the facts but draws from them some erroneous conclusion of the law. So, for example, if an individual agrees to repair a damage under the belief that she caused that damage and she was liable for it when actually someone else was guilty of causing that damage, the individual could argue that she made an error of law because the facts led her to believe falsely that she was bound by law to repair that damage. An error of law may also arise in an error as to the legal consequences of the contract. So when one party misunderstands the nature of the contract and the extent of his rights. So say a buyer buys a car, but he didn't buy a warranty in the initial sale of the car because he didn't know the seller wouldn't cover damage if he wrecked it. Then he wrecks the car. He totals it. And the buyer argues that he should get the warranty and argues that he made an error of law when he entered into the contract. So this isn't very persuasive, right? And that comes down to the effect of an error of law, and in actuality, it rarely ever leads to a nullity. So error of person is most likely to arise in gratuitous contracts, and this occurs because in gratuitous contracts, the donation to a particular person is the cause of the contract. And there exists a rebuttable presumption that honors contracts cannot be rescinded for error as to person. So an example of an honors contract that may be vitiated on the grounds of error of person is mandate, which is Article 2989. And it says that a mandate is a contract by which a person, the principal, confers authority on another person, the mandatory, to transact one or more affairs for the principal. So the contract of mandate is being made on a personal basis, the mandatory being chosen by the principal on account of the mandatory's qualities. So error as to the person or the qualities of the mandatory would likely be considered a ground for nullity of the mandate. So not all errors result in nullification. The seriousness of the error plays a big part in whether or not it is grounds to vitiate consent and thus lead to a nullity. And courts consider seriousness of the error using a reasonable person standard. So only serious errors that would be made by an average, reasonable, and capable person are considered grounds for nullity. The error also must bear on an essential requirement for a contract to exist, not an accessory element. So in terms of the effect of error, error can result in a relative nullity of the contract only if the error made by one party was detrimental to the other party. Nonetheless, a contract made in error may still be confirmed if confirmation is brought by the party who could also bring action for error. So if the person who is wronged by the error nonetheless wants to confirm the contract, it can still be viable and valid if that person brings forward an action for confirmation. A party may not avail himself of the error. So when the other party is willing to perform the contract as intended by the party in error, the other party can't benefit from that error. So if someone made an error as to, let's say, the sale price, and he set it for a lower price. So say you were paying $50 and he made a mistake and said $20. And the person nonetheless wants to go forward and confirm it and perform the contract as intended. The other party can't turn around and confirm it just because they made an error and it would result in him paying a lower price. So if the error is not detrimental to the person who's not in error, he cannot confirm it and reap the benefits of the error. In the event that rescission is granted, the erroneous party is liable for damages. So now we move into our second vice of consent, which is fraud. And Article 1953 provides that fraud is a misrepresentation or a suppression of the truth made with the intention either to obtain an unjust advantage for one party or to cause a loss or inconvenience to the other. Fraud may also result from silence or inaction. In analyzing fraud, we look at the two main elements, which are the material element and the psychological and moral element. In analyzing the material element, there are two different kinds of ways of looking at it. So fraud, in terms of the material element, can either be bad fraud, which results in nullity, or good fraud, which doesn't result in nullity. In terms of bad fraud, this includes maneuvers, schemes, behaviors, lies, withholding information, or silence for the purpose of leading a reasonable person to error. And this is grounds for nullity. If you're intentionally deceiving a reasonable person and a reasonable person would be deceived. Good fraud, which doesn't result in nullity, occurs when it's fraud that an average person would not fall for. So in terms of the psychological and moral element, we look at both the psychological aspect and the moral aspect. In terms of psychological, we look to the personal, physical, intellectual features of the party who made an error due to the other party's fraud. Because we know that not every person can ascertain the truth without difficulty, inconvenience, or special skill. So in other words, if the person was induced by fraud because they did not have a specialized, knowledge of the field, then this would fulfill the psychological element of fraud, or vice versa. If the person who is committing the fraud has a specialized knowledge, so if you're an attorney trying to commit some kind of legal fraud against a layperson, you obviously have more knowledge, more intellect in that field, whereas the layperson doesn't know anything about it. So this plays a big part in courts determining whether or not the psychological element was met. In regard to the moral element, this looks to whether the other party committed the fraud in order to obtain an unjust advantage or cause loss to the other party. So if they engaged in this fraudulent behavior with the intent to obtain that unjust advantage or to take advantage of the other party. Third-party fraud will also vitiate consent if the other party knew or should have known of the fraud. In the effects of fraud, the party who's the victim of the fraud has the right to seek a relative nullity of the contract. And if that contract is rescinded, the fraudulent party is liable for the damages. Moving into our third and final vice of consent, we have duress. Article 1959 provides that consent is vitiated when it has been obtained by duress of such a nature as to cause a reasonable fear of unjust and considerable injury to a party's person, property, or reputation. Age, health, disposition, and other personal circumstances of a party must be taken into account in determining the reasonableness of the fear. So like fraud, the elements of duress are a material element and the psychological element. So when we look to the material element, we look to what the party inducing duress actually did and if their actions constituted duress. Different ways that a party may induce duress is to threaten physical injury to a person or threat to one's health. If you threaten to bodily harm someone, an injury to property. So threat of injury to one's property just includes corporeal movables and immovables, which includes pets and things like that, or a threat of injury to their financial condition. It can also be a threat of injury to one's reputation, name, or honor. This is typically done through blackmail. And it may also be a threat against a third person. So threatened injury against a spouse, an ascendant, who would be their parents, or descendant, who would be their children of the contracting party, constitutes a material element of duress. And if the duress is directed against other third persons, the discretion is left to the court of whether or not that amounts to duress. The psychological element of duress is evaluated under both an objective and subjective standard. So the objective standard looks to whether the fear was reasonable, whether a reasonable, ordinary, prudent person would be fearful in that situation of unjust and considerable injury. And then it also looks at the subjectiveness of the psychological element. And this includes the age, health, disposition, and other personal circumstances of a party that would validate their fear and express that they would have an actual and real fear in this situation as to amount to duress. And these are just some other characteristics of duress that are important to note. So duress by a third person, consent is vitiated even when duress has been exerted by a third person. Note that this is different from fraud in that in fraud exerted by a third person only vitiates consent when the other party knew or should have known of the fraud. Here, there's no requirement that the parties of the contract know or should have known of this duress that's being exerted by a third person. In terms of exercising a lawful right, a threat of doing a lawful act or a threat of exercising a right does not constitute duress. So if someone is threatening to turn in a person to the authorities because they know this person's committed a crime, that's not going to amount to duress because that's a lawful act. And it just does not constitute duress if it's something that they could have otherwise done. In terms of a contract to prevent injury, this refers to a contract made with a third person to secure the means of preventing injury, and it may not be rescinded for duress if that person is in good faith and not in collusion with the party exerting the duress. So if someone hires a bodyguard because of duress, then that contract will not be rescinded for the duress. However, the cost of protection may be shifted to the party exerting duress. So if someone is threatening your family because you won't consent to a contract and you take out a different contract with a bodyguard, if the initial contract is vitiated because of duress, your contract with your bodyguard is still going to be valid. However, you may not have to pay for it and may be covered by damages if that first contract is rescinded. So in terms of damages for duress, when rescission is granted because of duress exerted or known by a party to the contract, the other party may recover damages and attorney fees. When rescission is granted because of duress exerted by a third person, the parties to the contract who were innocent of the duress may recover damages and attorney's fees from the third person. So that concludes our mini review on the vices of consent. Thank you for watching.